Hi one and all, this is me Rangu Satish, one of your favorite educator on the platform. So ladies and gentlemen, I believe audio and video is clear to you. Okay, one second. Hi guys, this is me Rangu Satish, one of your favorite educator on the platform, that is Unacademy. So this is me Rangu Satish, one of the verified and plus educator on the platform. I have been teaching on the platform for the last 2 years on Indian polity and law optional. And ladies and gentlemen, another announcement which I would like to make is that we do have the plus subscription right now for 1 month, 6 months, and 1 year. So I would recommend you to go for 6 months or 1 year subscription. By that, your CSE preparation will be well versed. And you can use Rangu Satish 1947 as a referral code for getting 10% discount on your subscription. So ladies and gentlemen, moving on to our class, that is we have been discussing 150 most important polity current affairs through MCQs. So far we had concluded 3 lessons that was held on 1st March, 3rd March and 5th March, and today this is a 4th session of this kind, and which is being held on 7th March 2019. This is not 5th March. So this is the class we are in. If you have missed any of the classes, you can go through the other classes by subscribing to this link. So ladies and gentlemen, let us get started with the lesson, and if you do have any doubts in between, please do let me know. By that I can clarify as clear as possible. So coming to the question number 1, consider the following statement. The penalty of death could be awarded only in the rarest of the rare case was laid down in Bachan Singh case in 1995. The Law Commission in its 22nd report recommended that the death penalty should be awarded only in terror related case. Which of the following statement given above is correct? Option A 1 only, option B 2 only, option C both 1 and 2, and option D neither 1 nor 2. So ladies and gentlemen, this particular question has been asked in the backdrop of Law Commission report, that is report name 262 on death penalty, which is considered as capital punishment. Okay, so ladies and gentlemen, so here the answer is B, that is 2 only. So coming to the explanation, the Law Commission, which is being constituted by the government, in its 22nd report recommended swift, that is quick abolition of death penalty, except in terror related cases. Nothing, it does not serve the penological goal of deterrence any more than life imprisonment. So ladies and gentlemen, here the point to be understood is that the Law Commission in its report says that the capital punishment, which is called as death punishment, could not hold its ground as the one which would deter the people from committing any crime in the future. Deterrence means stopping the people to do it. So it said that despite of having the capital punishment, it did not succeed the people to stop from committing any crime. Take for example the Nirbhaya case, which had happened in Delhi couple of years back. Despite of giving capital punishment to the culprits involved in it, there had not been any stop in the cases reported in relation to the rapes. So ladies and gentlemen, the Law Commission hence recommended that there has to be a capital punishment only for the people who had committed terrorism or who have been associated with terrorism in one form or the another. Moving on, in questioning the merits of retaining the death penalty, Justice Kurian Joseph has reignited a debate that is important and requires serious thought. So, what he said cannot be ignored, though the law laid down in Bachan Singh 1980 upholding the validity of death penalty and laying down guidelines for awarding death in rarest of the rare case still holds the field. So, yes, Rakesh Kumar, you are absolutely right. The case which had happened in December 2012, that was considered as rarest of the rare case, and it was reported as a Nirbhaya case. So, ladies and gentlemen, here a Bachan Singh case says that there has to be a death penalty, but it has to be given in the rarest of the rare case. Okay. So here the term says only in rarest of the rare case, which is considered to be wrong. The case says that it can be given in the rarest of the rare case, but it would not speak of any exclusivity as such. Hence, the answer is B, that is statement 2 only. Okay. So ladies and gentlemen, one thing I would like to clear is that whenever you see the term only in the options of the question, then that would be most probably be wrong statement. Okay, so you shouldn't go for any extreme statements like only, everything, or this only. So this kind of statement would usually be wrong. So hence do not go or subscribe for any statement which would speak of extreme words. So ladies and gentlemen, moving on to another important question. Consider the following statement. As per the Rights of the Persons with Disabilities Act 2016, nearly 3% of the population has one or more types of disabilities. Relief of the disabled is a subject under the state list in the 7th schedule of the Constitution. Which of the following statement given above is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. Here the answer is B, ladies and gentlemen, that is 2 only, because statement 1 is absolutely wrong, because according to the Act of 2016 or according to the census of 2011, the disability population is close to 2.21 and not 3%. Okay, so ladies and gentlemen, the point to be noted here is that relief of the disabled is a subject matter of the state list. As you all know, there are 3 types of list which is being mentioned in the 7th schedule of the Constitution. The first list is union list, on which the central government can make the laws, and the second list is state list, on which the state government can make the laws. Coming to the concurrent list, on which both the state and central government can make the laws. And there is another list as well, there is residuary list, on which only the central government can make the laws. So the point to be noted here is that the relief of the disabled will be covered under the subject matter of state list. So ladies and gentlemen, this particular question has been asked as the World Bank says that there had been underestimation or under numbering of the number of people with disability in India. Okay, it says that the reported number of disability in India has been quite low, despite of having good majority of them. So ladies and gentlemen, in India, according to 2011 census, that is considered to be the latest census, and the next census would be held in 2021, which says that 2.21% of the population has one or multiple types of disabilities, making the country home to one of the largest disabled populations in the world. And World Bank suggests that the numbers are nearly 4 or 5 times higher. So ladies and gentlemen, here the World Bank says that the number which is considered as 2.21% of the population is absolutely wrong, and they say that it would be way high as 4 to 5 times of what is being reported right now. So ladies and gentlemen, why there has been underestimation? Because the 2011 census does not does not include all types of disabilities. However, with the introduction of the Disability Rights of Persons with Disability Act of 2016, which has broadened the concept of disability and included 21 types of disabilities. Hence, afterwards, there have been many people who have been left earlier has been covered right now. So, the definition of disabled has been broadened with the Act of 2016 to encompass all the people with different types of disabilities. So, ladies and gentlemen, moving on to the following question based on the same concept, that is, which of the following is a provisions made by the Rights of the Persons with Disabilities Act of 2016? The Act applies only to individuals as being disabled by the latest available census. Reservation in vacancies in government establishments has been increased to 4% of persons for persons with benchmark disability. District level committees will be constituted by state government to address local concerns of persons with disabilities. Select the correct answer using the code given below. Option A 1 and 3 only, option B 2 only, option C 2 and 3 only, and option D 1, 2 and 3. So here the answer is C, ladies and gentlemen, that is 2 and 3 only. So ladies and gentlemen, coming to statement 1, which is absolutely wrong, because the act applies only to individual identified as being disabled by the latest available census, is absolutely wrong, because I have given already the explanation pertaining to it. So ladies and gentlemen, moving on to the explanation, that is statement 1 is correct. Refer explanation to the previous answer. And coming to provisions at the state and district level as per the act, which state that the state advisory board on disability are to be set up to serve as apex policy making bodies at the state level. What is apex? Apex means the highest policy making body. So at the state level, the apex or the highest authority would be the state advisory board. And coming to the Office of State Commission of Disabilities has been strengthened, who will be assisted by an advisory committee comprising of not more than 5 members drawn from experts in various disabilities. So the state advisory boards will be advised by the state commissioners of disabilities, which will have the composition of 5 members. So ladies and gentlemen, moving on to another important point to be discussed is that the state commissioners will act as regulatory bodies and grievance redressal agencies and also monitor implementation of the act at the state level. So ladies and gentlemen, as we have already discussed, the welfare of the disabled will be taken care by the state government, since the subject falls under the state list. So here the state commissioners would be monitoring the progress of the state in providing basic infrastructure to the people with disabilities. So moving on to another tier of administration of the schemes of disabled is district level committees, which will be constituted by the state government to address local concerns of persons with disabilities. So there would be committees at the district level as well, which would take care of the situations happening at the ground level. So state funds will be created to provide financial support to persons with disabilities, because this particular subject falls under the state list under the 7th schedule of the Constitution. So ladies and gentlemen, moving on to another important point, that is special courts will be designated in each district to handle cases concerning violation of rights of people with disabilities. Moving on to another important question. Including the Chief Information Commissioner, there are not more than 11 members in CIC. The Chief Information Commissioner, as proposed to other members of the CIC, cannot be removed from his office except in the same manner and on the same ground as a judge of the Supreme Court. The number of state information commissioners varies from one state to another state. Which of the following given statements are correct? Option A 1 and 2 only, option B 2 and 3 only, option C 1 and 3 only, and option D 1, 2 and 3. So ladies and gentlemen, there had been many questions relating to constitutional bodies, non-constitutional bodies, statutory bodies, among the other types of bodies. So there are a couple of questions which you will have to do before attempting your prelims on these bodies. So this is one kind of that question which you will have to do because this kind of questions can be expected in your prelims, which is scheduled on June 2nd, 2019. So here the answer is C, that is 1 and 3 are absolutely correct. So let us look at the explanation here. So the CIC, that is Chief Information Commissioner or Commission, consists of Chief Information Commissioner and not more than 10 Information Commissioners. So there would be a Chief Information Commissioner who will be assisted by other 10 Information Commissioners. So the President can remove the Chief Information Commissioner or any Information Commissioner from the office under the following circumstances. The first of that circumstance is if he is adjudged as an insolvent. Insolvent means the person who cannot repay his debt. That means he would lift his hand saying that I do not have any money to repay my debts. That's why we call it, if anyone defaults his or her payments, then we call him as IP person. IP means insolvency petition person. So we do often see these kind of cases in courts. So if he has been convicted of an offence which in the opinion of the President involves a moral turpitude. So ladies and gentlemen, take for example, if he had committed any atrocities against SCs, STs, women or senior citizens, or if he had committed any rape or molestation against the women of our country, then not only of our country per se, the women of any other country, so if it is being done by that person, then he can be removed by the President of India. And if he engages during his term of office in any paid employment outside the duties of his office. So ladies and gentlemen, either Chief Information Commissioner or Information Commissioner will have to work as a full-time employment, and they would not have to involve in any kind of office outside the employment. Or if he is unfit to continue in office due to infirmity of mind or body. So if the person is considered to be of unsound mind, if the person is considered to be mentally retarded, then he would be removed from his position to be Chief Information Commissioner or Information Commissioners. So if he has acquired such financial or other interest as is likely to affect prejudicially his official functions. So ladies and gentlemen, moving on to another important question. In addition to these, the President can also remove the Chief Information Commissioners or any Information Commissioners on the ground of proved misbehavior or incapacity. However, in these cases, the President has to refer the matter to the Supreme Court for an inquiry. So ladies and gentlemen, if the President of India feels that there has been misbehavior on part of the Chief Information Commissioner or Information Commissioner, then he will have to forward the petition to the Supreme Court of India to inquire into the misbehavior or incapacity of the persons. If the Supreme Court gives its recommendations regarding the same, that he is found guilty of misbehavior, then the president would not hesitate to remove that person from his position. So if the Supreme Court, after the inquiry, upholds the cause of removal and advises so, then the president can remove him. So the State Information Commission consists of State Information Commissioner and not more than 10 State Information Commissioners. So the number of State Information Commissioners varies from one state to another state. So it is a discretion of the state government to constitute how many members will have to be there in the commission. Okay, so it would be the discretion of the state, and it would vary from one state to another state. Moving on to another important question, that is, consider the following statement about telecom dispute redressal or settlement and appellate tribunal, what we called as TDSAT. So it was created by an executive order, that means the decision of the cabinet. The decision of TDSAT is final and no further appeal is allowed to any court. The jurisdiction of TDSAT stands extended to matters that lay before Cyber Appellate Tribunal and also the Airport Economic Regulatory Authority Appellate Tribunal. So here, which of the following statements are incorrect? The word to be seen here, that is incorrect. Option A 1-2, option B 1-3, option C 2-3, and option D 1-2 and 3. Here the answer is A, ladies and gentlemen. That is statement 1 and 2 are absolutely incorrect in relation to telecom dispute settlement and appellate tribunal. So let us look at the explanation of this particular question here. So in addition to these, the president can also remove. So this is not the point to be discussed. Here is the explanation. So the TRAI, that is the Telephone Regulatory Authority of India Act of 1997, was amended in the year 2000, and TDSAT was set up to adjudicate disputes and dispose of appeals with a view to protect the interest of service providers and consumers of telecom sector. Hence, ladies and gentlemen, TDSAT has not been the result of the executive judgment. So it is not considered to be the body which has been created of executive order. So it has been created by the Parliament of India by amending TRAI Act of 1997. So ladies and gentlemen, yes, I'll have to be a bit louder because I do have some problem with the laptop, I think. So I'll have to speak out a bit louder. So no one has kept any gun at my point here. So Ajkal has been saying that, so I'm not forced to do anything. So it's a voluntary thing and it is a free lesson. So please do get benefited by this lesson. So I would be getting my laptop repaired in few days. By that it will be clear to you, and I would be maintaining some decent tone. I would not be this louder because it is not required if it is repaired for some time now. So ladies and gentlemen, until then, please do bear my commanding tone. So moving on, the decision of TDSAT is appealed to Supreme Court of India. Okay. So moving on to another important question, that is National Register of Citizens. So National Register of Citizens has been in the news because of crisis which is going on in Assam due to illegal immigration from Bangladesh and other parts of the world. So ladies and gentlemen, since Assam has porous border with adjoining country called Bangladesh, hence it has been facing some illegal migration. Hence the government of India has come up with National Register of Citizens, which is unique only to Assam. So National Register of Citizens is a register containing names of Indian citizens residing in Assam The register was first prepared after the 1971 census of India. The recently released draft of NRC includes the name of Indian citizens who have been residing in Assam before March 25th, 1971. The update process of NRC started in the year 2013 under the monitoring of Ministry of Development of Northeast region. Which of the following statement is are incorrect? Option A 1-3, option B 2-4, option C 1-2-3, and option D 1-3-4. I'll give 30 seconds of the time to do this question. Please do it by yourself. So ladies and gentlemen, coming to the answer to this particular question is B, that is 2 and 4 are absolutely wrong to the National Register of Citizens. So let us look at the explanation here. The National Register of Citizens is a list that contains names of Indian citizens of Assam. Okay, so it would be consisting of all the names of the people who have been considered as legal citizens of the country who are residing in state of Assam. So it was prepared after census in 1951 and not after 1971. So the factual data which you have to understand, and the update process of NRC started in the year 2013 under the strict monitoring of Supreme Court of India, and Supreme Court of India has been giving the guidelines now and then in order to regulate the affairs relating to the NRC. Moving on to another important question. Consider the following statement about Consumer Protection Act of 1986. It makes provisions for the establishment of consumer councils and other authorities for the settlement of consumers' disputes. It protects the consumers against the marketing of hazardous goods and services. Wherever possible, it assures access to goods and services at competitive prices. Seek redressal on account of unscrupulous exploitation of consumers. Which of the following statement above is correct? Option A 1-2, option B 1-2-4, option C 1-3-4, and option D 1-2-3 and 4. So here the answer is D, ladies and gentlemen. Coming to the explanation of this particular question, the objective of Central Consumer Protection Council is to promote and protect the rights of consumers such as, so ladies and gentlemen, the rights of consumers has been firstly recognized by the Consumer Protection Act of 1986. So ladies and gentlemen, there had been undue influence being exercised by the service providers before 1986. Hence the Consumer Protection Forums had fought to create some kind of act which would regulate the consumer protection. Hence the Parliament of India had passed the Consumer Protection Act of 1986 to protect the rights and interest of consumers. So the rights to be protected against the marketing of goods and services which are hazardous to life and property. So ladies and gentlemen, here the Consumer Protection Council would be overseeing what are the goods circulating in the market which would cause hazardous to life and property. If that is being recognized by this council, then they would ban those goods. Take for example endosulfan, which has been banned by this council. So the right to be informed about the quality, quantity, potency, purity, standard and price of goods or services as the case may be, so as to protect the consumer against unfair trade practices. Okay, So ladies and gentlemen, the right to be assured wherever possible access to variety of goods and services at competitive prices. So here this council would see whether there is any monopoly existing in an industry. So there would be big business conglomerates which would create monopoly kind of situations which would exploit the consumers from exercising their rights and duties. Hence, ladies and gentlemen, this council which would protect the consumer against those unfair trade practices. Moving on to another point to be discussed, that is the right to be heard and be assured that consumers' interest will receive due consideration at appropriate forums, the right to seek redressal against unfair trade practices or restrictive trade practices or unscrupulous exploitation of consumers, and finally that is right to consumer education, that is making the consumer aware of what are the goods which shouldn't be consumed upon and what are the goods which should be consumed. So here they would make all the campaigns to make the consumer educated in relation to the goods and services to be used by him. So moving on to another important question, that is consider the following statement about Central Drug Standard Control Organization. So the Central Drug Standard Control Organization is under Directorate General of Health Services, Ministry of Health and Family Welfare. The Drug and Cosmetics Act of 1940 and Rules 1945 have entrusted various responsibilities to central and state regulators for regulation of the drugs and cosmetics. These regulations of manufacture, sale and distribution of drugs is primarily the concern of the central authorities. Which of the following statement is correct? Option A 1 only, option B 1 2, option C 2 3 and option D 1 2 and 3. Here the answer is B, ladies and gentlemen, that is 1 2. So let us look at the explanation pertaining to CDSCO. So Ministry of Health and Family Welfare is a national regulatory authority of India, and the Drug and Cosmetics Act of 1940, very important act which would regulate this pharmaceutical industry, and rules of 1945 have entrusted various responsibilities to the central and state regulations for regulation of drugs and cosmetics, and the regulation of manufacture, sale and distribution of drugs is primarily the concern of the state authorities, while the central authorities are responsible for the approval of new drugs, clinical trials in the country, laying down the standards for drugs, control over the quality of imported drugs, coordination of the activities of the state drug control organization, and providing export advice with a view of bringing about the uniformity in the enforcement of the Drugs and Cosmetics Act. So ladies and gentlemen, moving on to another simple question here, that is the power to establish a common high court for 2 or more states rests with President of India, Chief Justice of India, state legislature of the concerned states and Parliament. Here the answer is D, that is Parliament. So ladies and gentlemen, Parliament has the power to establish a common high court for 2 or more states. So coming to Article 231 Clause 1, which says that the Parliament of India by law establish a common high court for 2 or more states or for 2 or more states and a union territory. So ladies and gentlemen, you can take the example of a common high court for Punjab and Haryana, and you can take the example of Andhra Pradesh and Telangana. However, it has got bifurcated and they do have separate high courts right now. So ladies and gentlemen, with this we come to the end of this session. So ladies and gentlemen, if you do have any doubts, please do write down in the comment box. By that I can clarify it. So ladies and gentlemen, you do have the Plus subscription right now on Unacademy platform, and if you would like to subscribe to it, please do use my referral code, that is Rangu Satish 1947. By that you will get 10% of discount. So ladies and gentlemen, great educators are teaching on Unacademy Plus, so you don't have to go to Delhi to take coaching. You can take your coaching right sitting in your room, in front of the laptop, where you will get access to all kind of material, teaching and live classes. So please do subscribe to this Unacademy Plus and use the referral code as Rangu Satish 1947. By that you will get 10% of discount. Another important point to be made here is that please do install Unacademy learning app and go and find my name Rangu Satish, where you can access free courses, absolutely free courses on Indian polity, where I have taught Lakshmikant's Indian polity book in 76 days, and where I have done various courses on Indian polity like polity MCQs based on NCRT books, and I have also discussed about the polity MCQs chapter wise. So you can access to these free courses by installing Unacademy learning app and searching my name in the above said app. So ladies and gentlemen, thank you so much. Thank you so much for being with me in this particular lesson, and thanks to each and everyone who has joined me live on this platform. And thank you so much Adil Khan for giving me the compliment of maintaining good quality of MCQs. Thank you so much, and please do join me live day after tomorrow at the same time, and where we would be discussing another couple of questions on Indian polity. Until then, thank you so much and have a good preparation, because you do have prelims around the corner. Thank you so much, ladies and gentlemen. It's been great honor indeed. Thank you.